Good morning. Call the Legislative Committee on Administrative Rules to order. The first item on the agenda is to approve the minutes of September 23rd, 2021. And before we do that, we will go around the table and briefly introduce ourselves. Senator Benning.
Good morning. My name is Joe Benning. I'm a state senator from Caledonia County. I chair the Institutions Committee and serve on Judiciary.
And I'm representing Mark Higley from Lowell. I represent Lowell, J. Westfield, Troy, and Eden, and I sit on government operations.
Senator Chris Bray from Addison District, and I serve on natural resources and energy.
My name is Anthea Dexter Cooper from the Office of Legislative Counsel, and I help this wonderful committee.
Mark McDonald, Chair of Lcar. I represent most of Orange County.
Jenny Lyons, Senator representing Chittenden County, Health and Welfare and Education Committees.
Carol Odie, State Representative from the far new north end of Burlington, and I'm on the House Ways and Means Committee.
Seth Bongas, I represent Bennington 4, and I'm on the Natural Resources Fish and Wildlife Committee.
And with masks on today, it's difficult for those of us here to hear each other, and certainly difficult for folks at home. So we'll do our best. First item of agenda, minutes of September 23rd. Do we have a motion?
So move.
It's been moved that we approve the minutes of September 23rd. Thank you, Representative Higley. Is there any discussion? If not, all in favor say aye.
Aye.
All opposed say nay, and the minutes have been approved. Okay. Second item on the agenda is the rules dealing with Office of Professional Regulation, Emergency Administration, rules for notaries, public and remote notarizations. Title is 21E14. And Lauren Lehman, staff attorney for the Secretary of State, will brief us on what we may or may not need to know.
Morning, all.
And Ms. Lehman's on the screen.
It's a little disconcerting. I can see myself in 3 places right now on my screens. Good morning, all. I'm here again with the emergency administrative rules for notaries, public and remote notarization. This was an emergency rule originally introduced in March of 2020 as a way to facilitate ongoing transactions in legal paperwork during the pandemic. There's a requirement in the notary public statutes that requires an in-person meeting between the notary and the person signing the record, and that is for an identification verification purpose. The rules facilitate this remotely through an audio-visual communication and sending the document. So still a wet signature on the document by both the individual signing it and the notary. And so that record still is still a paper record. We find ourselves continuing to have a difficult time with in-person meetings with the risks of the Delta variant. And so we're seeking another renewal of these rules. We are hoping so it'll be, if approved by the committee, it would be through March 2021. We do have a longer term strategy in place, or a longer term goal in place, I should say, to seek a more permanent solution from the legislature this session.
I have a question.
That's all I have.
Before I ask a question, it's fair to characterize this emergency rule as a rule which continues the emergency rule that's currently in place.
Yes, it is exactly verbatim. No changes have been made at this time.
Thank you.
I have one question, which I probably should know the answer to right now, but is there any statutory language about this rule, the emergency rule? Was there anything during the COVID emergency that allowed for it to continue for a specified period of time? Or is this promulgated independently of any statute?
So it's not completely, and it's independent of any emergency statutes that were enacted or adopted during the COVID emergency. So the rule is based on an interpretation of the permanent long-term notary public statute that allows the Office of Professional Regulation to establish rules for communication technology and remote notarization. So the OPR has been given the authority by the legislature to make rules regarding remote notarization, and we used that authority to create these emergency rules when the pandemic hit.
So there's nothing that indicates that this rule would end with the end of the emergency or a period of time after the emergency.
No, it's not tied to the state of emergency, nor is it tied to a specific date other than the 180 days for emergency rules. There's also federal efforts now, as well as hopefully efforts in the Vermont legislature to do something more permanent so that we're not coming back to this rule over and over again, because it has functioned well in Vermont during this time. And I think nationally, as with many things during COVID, folks are noticing that more can be done remotely. So.
Thank you. Any further questions? Representative Odie.
Thank you. Just under the environmental impact analysis, I think it might have a positive impact on the emission of greenhouse gases and a positive impact on the climate for this rule to go into effect.
To the degree people do not need to travel to engage with a notary public, I would agree that that could be a possibility.
So I'm just wondering if that should be changed in this environmental impact analysis.
I'm happy to make that revision if the committee would like.
Are there any further questions? Question before us is, shall the emergency rule now in place be extended until March of 2022? Or until such time as the legislature changes the law? Representative Bongartz? Representative Bongartz has moved we approve the rule. Is there any discussion? Senator Lyons?
So understanding that we are in a Delta situation at this point, it does make sense to extend it, but I'm wondering if we should also consider sending a letter to committees of jurisdiction or to OPR that might seek some legislative action on this, or at least a discussion about it, and whether the emergency rule becomes permanent in some way or influences statutory change. So I don't know that we need to add this to the motion, but we might want to consider it at the end of the meeting.
May I speak to that, Senator?
That's open for consideration before the end of the meeting. And the question is, shall this rule as set forth be voted favorably? Any further discussion?
She had asked to speak to it.
Senator McDonald, may I speak to that? We do have legislation that in the works, and OPR is reaching out to the committees on jurisdiction as well. Not to dissuade you from doing so as well, but I wanted to let you know that that is in process. Because there's a federal effort that may take over, we've had to kind of reshuffle our plans a little bit. It's been attached to the National Defense Authorization Act in the House. So we might have a federal mandate pretty soon, and we've had to shuffle some of the deck chairs. So we're working on that effort at this time.
Question is, shall the rule be approved? If there's no further discussion, all those in favor say aye.
Aye.
All opposed say nay, and the rule has been approved. Thank you very much for your testimony.
Thank you.
21E15, Office of Secretary of State, Rule on Rulemaking. Chris Winters who's
Chris
representing Chris?
Chris couldn't make it this morning. He got tied up in some other matters. So I'm Louise Corliss. I'm the APA coordinator with the Secretary of State's office. And Angela Valentinetti is here with me to answer any questions. Generally speaking, this emergency filing was made to fill the gap that occurred from our permanent rule going into effect. We hit Lcar without a quorum a few weeks ago. So our emergency rule that was in place was lapsing, and we didn't have our permanent rule in place. So we filed this emergency rule to fill the gap.
Are there any questions? For folks listening, some would characterize this vote as a procedural issue. We did have a gap that required some notice. The notice is that time has taken place, and this is it would be the formal opportunity to adopt the rule that we've discussed at length at previous meetings with no objections raised. Senator Bray.
I would move approval of Rule 21E15.
Senator Bray has moved that the rule be approved. Is there any further discussion? If not, all those in favor say aye.
Aye.
All those opposed say nay, and the rule has been approved. Ms. Corliss, thank you very much. Okay. Next item on the agenda, we're running a bit ahead of schedule, is a public hearing on emergency housing waivers and variance rules. The agenda calls for a hearing, but the hearing may not take place unless this committee, which has expressed an interest in having a hearing, votes affirmatively to hold a hearing. The hearing has been warned with adequate time, but we will first have to go through a procedural vote to authorize the hearing that we hope to have. Anything to, counsel, anything to add to that?
That is accurate. I could read you some language from your procedural rules or the statute if the committee would like. This was in the summary email that I had sent out as to the sort of process. You warned it the 10 days, and now there needs to be the vote. And unlike some of your votes, it needs to be a majority of, in this case, not just those present, but of Lcar, which you have virtually your whole committee here today.
One short.
Any questions from Senator Benning?
Anthea, I'm curious about the process. Not on the fence with this. I think we should offer people an opportunity to have a conversation. But I am also wondering about the precedent that we establish, as well as what remedies we could possibly provide. And I did read your memo, but I think it would be important for people who may be watching in the public to give a brief overview of your memo, as well as what potential remedies or lack thereof we possess as a committee to make sure people who may be testifying with interest and a thought process that may include a desire us to do some action to understand what the limitations are of Lcar and in fact what possible remedies Lcar might provide. I would find that to be very helpful.
Certainly. So this hearing was warned under 3 VSA section 817C, which is in statute, and it was also warned under your own procedural rules. Section 817C says that the Legislative Committee on Administrative Rules may hold public hearings on a proposed or previously adopted rule on its own initiative. So I'm going to pause there. One of the things that might come up in this hearing is whether or not these emergency housing rules are rules as defined under the Administrative Procedures Act. So 817C is one of the ways that this has been warned but I think that there is some discussion that might come up as to whether or not there's a rule. But as I'm going to go into, you can still have the hearing, and that's why we're going to have this vote. So if you were going to have your hearing under 817C, this is still in statute, the committee shall give public notice of any hearing at least 10 days in advance and shall notify the agency affected. That was the notice that went out on the 11th of October. It was posted to the committee's page. It was sent to members of the Agency of Human Services and the Department of Children and Families. So you have met your, and the language goes on to say what else happens at the hearing. So you have met that requirement. If it is not a rule, one of the things that you have in your own procedural rules, these for members that have been on the committee before, this is what you finished off in January of 2021, where you made some updates to it. And there actually was some discussion around the agenda setting. In the case of your agenda, any committee member or staff may bring up as new business an item that the individual believes is deserving of the attention of the committee. So that doesn't link it to, is it a rule or has it been adopted or is it proposed or anything like that. Your procedural rules go on to say, any new business brought up under this section shall be pursued and investigated by the committee if a majority of the entire committee approves of further inquiry. So that's why you're going to have this vote. So you're covering both bases. You did your notice requirements under statute if you're having a hearing on an existing rule, and you are going to have your procedural vote. And if the majority of the committee wants to pursue it, you'll pursue it and you'll have this hearing. As for what remedies Lcar might be able to provide as part of this hearing, statute, this is still in section 817, goes on to say, in addition to its powers under section 842, and that's Lcar's normal objection authority for permanent rulemaking, language that is very similar in 844 for emergency rulemaking. So in addition to your powers under 842, the committee may, in similar manner, conduct public hearings, object, and file objections concerning existing rules. A rule reviewed under this subsection shall remain in effect until amended or repealed. That's going to put us back to this question of, is it a rule? And then even if Lcar does object under 817D, it is not going to change anything about the rules, much like if Lcar objects in its normal course to object, the agency has the ability to respond. And then if Lcar still wishes to pursue the objection, it's certified with the Secretary of State's office. And then this is when I start talking about putting the red letter on the rule. There is this shifting of a burden of proof as to the validity of the rule if the rule is challenged in litigation. And then your bases for objection are things like contrary to legislative intent, arbitrary, not in the right style, not following the requirements for public hearing and public involvement. So if you are going to object, you're going to be in a position where it's very similar to Lcar's normal process. And much like in your normal process, Lcar is both very powerful in terms of sort of putting this mark and shifting the burden on a rule, but very limited in terms of Lcar doesn't write rules. Lcar is simply part of the process in approving rules as they are adopted by the agency that is adopting the rule. So hopefully that covers things, and I'm happy to go into more detail.
Well, I appreciate that foundation very much. I'm sure for those watching at home, this is an educational experience, as it is for virtually all of us. A couple more questions. In your opinion, are we dealing with a rule per se?
I think there is a lot that sort of went on in terms of the legislation that the administration has potentially pointed to. And I think you're going to want to hear from them in terms of what they think their authority is, what they think this is. What I will do, which is what I really love to do, is point to definitions. And I will say that in the Administrative Procedure Act, there is a definition for rule. Rule means each agency statement of general applicability that implements, interprets, or prescribes law or policy, and that has been adopted in the manner provided by sections 836 to 844 of this title. And that is the rulemaking adoption in the Administrative Procedure Act. The Administrative Procedure Act also defines things like procedure, practice, guidance document, which are not rules, they are other things. and includes in the purpose of the Administrative Procedure Act that when an agency adopts policy, procedures, or guidance, it shall not do so to supplant or avoid the adoption of. I will give you that frame.
So did this particular conversation go through the process you just outlined?
It is my understanding that what is labeled as the emergency housing rules, which we have linked in that email that I sent out, they say emergency housing waiver and variance of rules. This document did not go through the rulemaking process with ICAR, Lcar, the public hearing, either as an emergency rule or as a permanent rule. So you have not seen this yet in your capacity as a member of Lcar.
So if I can use a comparison analysis, there is at present something called Administrative Order 49 that the Judiciary has sent out, which effectively, among other things, makes decisions about the trials, what courthouses should be opened or closed. Is that a conversation that could be brought to Lcar in a similar fashion if we open this door to have these kinds of conversations?
Under your procedural rules, where it basically says Lcar can take up anything if a majority of the committee wishes to, I think you could, but when you're dealing with rules under the Administrative Procedure Act, that is agency, not the judicial branch. So I think you're then dealing with different branches of government, but in terms of what your procedural rules say, it is very broad in terms of you can take up what you wish to take up, provided that your colleagues are in agreement that it's something that warrants further investigation.
Okay. Mr. Chair, I have one other question, but not to council. I'm going to turn to Senator Lyons. In order to figure out what the legislative intent is here, has the legislature actually expressed its intent in such a way that we can have a reaction to the conversation I think we're about to have?
So my response would be to review the information that our Ledge Council sent to us regarding the extension through March 2022 of the ability of AHS to modify its rules, and adopting emergency rules, and then to go further through and look at the budget language that is there. So in one sense, as our committee discussed, we did not want to leave any folks without housing while we were in this health emergency. And we understand that the Delta variant continues. So, but we did give latitude to the Agency of Human Services and DCF to make decisions about emergency rulemaking in this case, but we haven't seen rules. I guess that's one of the issues we're discussing. The budget language clearly indicates that when funds run out, then the agency has the option of continuing or terminating, that the funds become the dictate what's possible. But that was never a discussion in the Health and Welfare Committee, nor I think our concern was to have a policy in place that would help people find and have housing during cold winter months, and particular during the emergency.
Senator Bray.
I have a couple of questions for council. One is we were referencing, or Senator Lyons was referring to, a state of emergency. So legally, what status are we in terms of COVID and the state's response to it? Is there an active?
I just let me clarify that the statute that's in place allows for this, the emergency rules, to go through March 31st, 2022. So an extension of coverage of housing for people during that time. Our concern in our committee was that we're going to see the fall surge as we have, and that we don't know what the consequences of that would be on people who are without housing. Compounded by the fact that we're always concerned about the cold weather and what effect that has on people who are without housing. So to ensure two things, one, that folks who are homeless or without housing for some reason are provided with healthcare protection during COVID or an extension of COVID, and not the emergency itself, but the disease, and that people have access to housing during these cold winter months. That's always been a concern and a policy discussion in our committee.
So I'm sympathetic to the point of view you're presenting. I just wanted to make sure we
Okay.
weren't going to be tripped up by someone asserting that there's not a legal state of emergency, for instance, but if there's statute that already says it extends to next March, would it be correct that regardless of a state of emergency, the law is enforced?
So I would direct, after this one, which I can answer, some of the more substantive questions to my colleagues who are here, Jen Carvey and Katie McClin. I will say that Senator Lyons is completely accurate in what she just said, seemingly from memory, in terms of the language in Act and Resolves number 91, section 1, which was one of the very first COVID relief bills, as it was most recently amended by Acts and Resolves of this year, number 6, and it says through March 31st, 2022, and that is a date that has been modified, has been pushed out through legislative action to amend it. The Agency of Human Services shall consider modifying existing rules, et cetera, et cetera. This language is not linked to there being a state of emergency.
Okay. If I may, Mr. Chair, a couple follow-up questions. One is, so you outlined two doors that sort of led us into this inquiry. One is there's an existing rule or assertion that there's a rule, and so we have the ability to look at it. The other is that if we're vote to look into something, we can do that as well. Our powers in terms of following up, do they vary? Are there things that we can do in response to an existing rule that we look into that we can or cannot do if we say, here's a topic of interest and we want to look into it?
That is a fantastic question. So the language that I read from statute that talks about existing or proposed rule and then says there's the power to object, that is linked to it being a rule. And then I think you're going to get to your discussions about, is this a rule? As for the general, more overarching power of Lcar to take up in a meeting anything that it's interested in, provided that there is interest of Lcar as a whole, that does not then specify what powers Lcar has as a follow-up to taking something up on its own accord without regard to it being a rule or not.
So I'll ask you to speculate. I mean, might Lcar make a general inquiry and then write to a committee of jurisdiction and say, we would urge you to look into something, or can Lcar do something more direct itself?
So in terms of, Lcar can always sort of write a letter, but what the statute says is at any time following its consideration of a final proposal under section 841 of this title, the committee by majority vote of the entire committee may request that any standing committee of the General Assembly review the issues or questions presented therein, which are outside the jurisdiction of the committee, but are within the jurisdiction of the standing committee. So in your normal course, when you are sending a letter as Lcar, you're doing so under that statutory power, which is linked to one of the normal hearings that you have on rules.
Okay, and last for the moment at least is what body has the ability to determine whether or not a document published by an agency constitutes a rule and therefore lets us use the Lcar provisions around reviewing the rule? Who makes the determination that it really is a rule?
That is not addressed in statute.
Compensation of the person.
Thank you.
If I may try and boil this down a little bit. Our job is to check the homework when the administration makes rules. And we often ask administrations to make rules to carry out the laws that the legislature passes. We would be full-time legislature if we had to sit here and deal with all the tiny details of laws. We ask the administration to write the rules. We're having a hearing, we may be having a hearing shortly to understand what's going on. And if we believe that a rule is not being followed, we can object. If we find that there is no rule for what's going on, and time has been long enough to have come up with a rule, but policy decisions are being made without any rules, we can object. It is right and proper during emergencies for administrations to do the things that need to be done now. And it's right and proper for administrations at some point to say, we, the administration, need to go back to the legislature and ask the legislature to direct policy. This committee today, and anytime we don't make policy, we're prohibited from doing that. But we point out when policy is not being followed, in our opinion, or there is no policy because the legislature hasn't put it in place. And emergencies are that kind of murky middle ground, and we're here to learn what's going on. And at the end of this hearing, we may adjourn to learn more at a future date, or we may come to an opinion. But I would ask that if there are no further questions, that the members of Lcar, we have a motion to actively engage in the hearing. We move ahead and listen to what the witnesses might have to say. Should we vote to hold the hearing?
We have
So moved.
There's been a motion made that we enter into the hearing process. Is there any discussion? Senator Bray?
Just for clarification, are we determining which way we're getting involved in this? Either that by claiming that there is a rule and we want to examine it, or that we're opening an inquiry based on general interest? We need to specify that in our vote.
We are having a hearing to learn what's going on. And when we learn what's going on, we may have some opinions on whether we wish to take further testimony or further action. The legislature is not in session and will not be in session until January. And in the absence, and when there are emergencies, we expect government to act. When there are longer periods without established policy, we expect that policy will be developed and there'll be public input on that policy. We cannot do that. We cannot set policy. We're here to find out what's going on. And we may have a recommendation. And we may just thank the witnesses and say, well, in January, maybe some things will be done, but we can't do that until we have our hearing. Senator Benning.
So, Mr. Chair, I think this is a good opportunity for me to try to explain my vote because we're not normally voting individually. I plan on supporting the motion, but I do also feel that we are stepping into territory that potentially opens a very large door. At the very end of the day, however, I think the people have a right to have their grievances heard. And as I see it, the current situation with what's going on in the world of homelessness is such a grievance that is worthy of consideration by the body. I'm not sure we can provide the remedy that will be satisfactory, but I do believe in default that the people should have a forum available for people to be able to be heard. So with that, I will support the motion with the cautionary flag that I think we should have a substantive conversation in the future for any such proposal that comes before us because that conversation is also worthy of being able to identify what Lcar's actual function is supposed to be about.
Senator Lyons.
So I appreciate what Senator Benning is saying. But having said that, I'm also very concerned that we haven't seen a rule on this because the issue itself, and I'm hoping we'll hear more about the issue itself. The issue itself has always been a difficult one, and it has a very firm policy base in human services and health. And when the debate continues to be about having sufficient resources to accomplish our goals to help folks who are homeless. But I think while we are not the policy committee itself, I think it's very important for us to hear what people have to say about the effect of any changes that are going on. And then we can make a decision whether we're going to vote on something or we're not. I agree with Senator McDonald on that. Any other request that comes to us, we can deal with individually and determine whether or not we want to act on it. I think, but I do think I agree with you. This is an opportunity for the public to hear and to understand. Public hearings are always critically important for Vermont citizens. So I agree with your sentiment in that way. So thank you.
Thank you, Senator Lyons. This committee does not establish policy. We do not make the policy. We do not make the rules. But when policy is seems to be taking place during emergencies, that's one thing. If we think that they should have a formal process for establishing policy through the legislature, that's another thing. Administrations are always in a difficult position. They're damned if they do and they're damned if they don't. And we'd like to know what's going on. So this hearing will give an opportunity to hear. Is there any further discussion? If not, all in favor of opening the hearing, say aye.
Aye.
All opposed, say nay. And we are now holding a public hearing on this topic. Senator Bray.
Just to keep track of things that are coming up while we're working, I'm wondering if we can set aside a note to come back to ask Lcar to discuss the gap in law that addresses whether or not agency action constitutes.
I can't hear.
I can't hear you.
I asked, this came up in our discussion in the last 20 minutes, half hour. I'm wondering if we might, as a committee, discuss the gap in law that appears to exist about would address whether or not agency action constitutes a rule, policy, or so that we would know how we're engaging in reviewing something. We have two ways into it, and it seems as though it might be helpful to us to know which way we're beginning the inquiry. Because of consequences, I don't fully understand yet about what possible actions are, depending on how we assert we're engaging in the inquiry.
Can I respond?
Oh, okay. We don't know what our possible actions are because we haven't had a hearing. So
That's very.
this is.
Just, you're covering your bases right now.
Yep.
There is the 10-day notice, met the requirements at 817C, and you've met the requirements under your procedural rules. So I think, as the chair just said, you're leaving your options open.
Thank you.
So now that we've started the hearing, we're going to listen to witnesses, and it would be, chair believes it's appropriate to ask the administration to share with us the decisions and recommendations that are being made in today, tomorrow, and recently. And for the administration here today, online.
Yes, good morning. This is Sean Brown, Commissioner from the Vermont Department for Children and Families.
And thank you, welcome, and thank you. My apologies, I didn't have a list, and thank you for this morning on letting us know that you would be here. The floor is yours. Tell us how you're working on this difficult situation.
Sure, and with me today, I have Deanna Jones, who's with us for 2 more days before she retires. She's a policy attorney within the Department for Children and Families. And then with me also, I have Sarah Truckler, Chief Financial Officer, who is also very involved in this area as well. Just to provide some additional context for the committee, last winter during the budget process, emergency housing was a topic in the House Appropriations and other policy committees. And the House Appropriations Committee drafted language that passed the House version of the budget that created what we refer to as the GA working group. And that language asked this group to put forth a proposal for consideration by the full legislature on what the emergency housing program would look like in state fiscal year 22, the current year we're in. As it's been discussed in the committee, we were given authority by the legislature to modify and vary rules. And at the start of the pandemic, we varied our rules by waiving the eligibility criteria. And so anyone who was homeless and needed a place to quarantine and stay home, stay safe under the state of emergency that was in effect at that time, had a safe place to go. At the height of the pandemic, we were housing just over 2,000 households in motel rooms across the state. That was in April of 21 in state fiscal year 21. So the GA working group was formed. That included leadership from the Agency of Human Services and the Department for Children and Families, as well as policy experts from the agency and the Department for Children and Families. It also included leadership and policy experts from the Department of Housing and Community Development. And it also included participation from community partners or community groups. And they included Rita Markley from the Committee on Temporary Shelter. It included Tom Donahue from the Bennington-Rutland Office of Economic Opportunity. It included Margaret Bozit from the Champlain Housing Trust. It included Paul Dragon from the Champlain Valley Office of Economic Opportunity. It also included Josh Davis from Groundworks Collaborative in Brattleboro. It included Michael Redman from the Upper Valley Haven in White River. It included Jessica Radbourd for Vermont Legal Aid. And it also included Kara Casey from the Vermont Network Against Domestic and Sexual Violence. In total, in coming up with a proposal and then drafting rules to implement the proposal that was passed by the legislature, the GA working group met 16 times between April 1st and June 3rd. And for some of those meetings, they went for several hours or significant periods of time. That group put together a proposal that was submitted to the legislature on April 21st. There was then substantial testimony provided to many of the different policy committees and appropriations committee by myself, and it also included other members of the working group, including Jessica Radbourd. That plan was unanimously supported and included in the budget, which implemented new eligibility criteria for the program starting on July 1st. And it treated folks accessing the program differently depending on if you were in the program before May 31st or if you were a new applicant after that point, you were subject to the new rules. Those rules are still significantly expanded from the emergency housing program rules that still exist that predated the pandemic. They expanded the categories of who was eligible and also the number of days they were eligible. And it also included abilities for extensions for certain categories, which had never existed in the program prior to the pandemic. So based on the language that was included in the what was in the law, the budget bill, rules were then promulgated with the working group as well. Again, there was almost unanimous agreement on all areas of the rule except for one regarding the area of disability category. After the rules were published, Vermont Legal Aid filed a lawsuit on behalf of several participants in the program challenging the definition of that rule. It was originally filed in state superior court, what then was removed to federal court. And then an agreement was reached between the state and the plaintiffs in that lawsuit on August 19th. That settlement agreement expanded the definition of disability, which was then updated in our rules based on the settlement agreement. And that settlement agreement also settled all claims between the plaintiffs and legal aid regarding the rules and the definitions included in the rules, and included that there would no longer be any further legal challenges to the rules as a result of that settlement. Those rules do include a limitation of 84 days, with families with children being able to request 30-day extensions as long as they're cooperating with services and case management. It also allows households who are eligible under the disability category to request extensions if they have a disability that impacts a major activity of daily living. Both of those processes have been implemented and are available, although given the pause, they've not been utilized yet. As those have indicated, there were a lot of dialogue has occurred up to date regarding the rules that are in effect under the budget language that became law. There is language in there that allows the commissioner, I believe, to expand eligibility, but not restrict eligibility. And the authority to expand eligibility is in response to a public health emergency. Vermont state of emergency ended earlier this year or even before. I'm not the exact date. It was either in June or early July that Vermont came out of the state of emergency. Notwithstanding that, the governor did issue an initial pause as many households that were initially eligible under the new rules for 84 days were approaching their end of their eligibility in the program. The governor issued a pause in people being asked to leave the program at the exhaustion of their 84 days to allow time for the working group and the administration to work together to come up with a new plan moving forward. The working group met for several times recently to gather input and feedback from the working group members, which helped inform the plan that was presented earlier this week, which allows folks to continue to stay in the program beyond 84 days until December 31st of this year, with the also requesting the legislature fully fund the governor's initial ask last year of $249 million for permanent housing investments to build and expand low income and moderate income housing in the state. Also to create a new program that will be administered by DCF that will allow folks in motels beyond the 8 that are now in the hotels beyond 84 days stay in motels on a longer term with more stability. It will be a rental assistance program, and we're working through the details now. It is our goal to make sure that all vulnerable folks in the program now, households in the program now, are able to remain housed in a motel room long term under this new program. The funding available that we'll be using that the legislature allocated in our budget, emergency rental assistance, is eligible for households between 15 and 18 months. And so we'll be using those funds, which will allow folks to be able to be continued to be housed using those funds for that duration. Also, we have our adverse weather policy, which has been in effect for many years. It was previously called cold weather exception, where those who are not eligible for the program or exhausted their eligibility historically would be eligible to be housed during the cold weather months to make sure everyone has a safe place to stay. Those rules will be, policy will be in effect now, moving forward. And so that is where we find ourselves now. We did promulgate or post modified and basic rules.
I'm gonna, excuse me, I apologize. It's always difficult to lead off on a hearing. And we're the Rules Committee. And
Yes.
if something was established as a rule, it came to us. If the administration put a committee together of, like you told us, of a group of folks with wide knowledge and experience and well-versed to delve into the issue that the administration is working on, that's terrific. That's part of rulemaking. But we don't, our counsel tells us, and our memories tell us, this rule has never come to us. So legally, you've often referred to it as policy, that your policy is, or this is what you're doing, but it's not a rule until it comes to us. And that doesn't, the statement doesn't mean that what you're doing isn't useful, good, worthwhile, and appreciated, but it's not a rule. And when you use the word rule to this committee and in law, it's a pretty specific thing. It means it's gone through a process. And I'm perhaps being overly technical, but the
Senator, I think
administration
we're
has asked for and gotten appropriation, absolutely, to do certain things. And that was voted on, and that's law. So I could turn this over to counsel who would take longer to say it than I did. But
well, I was moving into the piece of what authority we use to issue the modified and varied rule that we did, and Dee Jones is here to walk you through the authority granted to us by the legislature to do the process that we move forward with for this modified and varied rule. Understanding that the timing of the budget bill and the law going into effect required, and where we were at required quick action. And Dee, I would turn it over to you to explain the authority we used in the process we used.
Thank you. It's the word rule has a meaning, and what you have worked on with length and with a lot of experts is coming up on policy for this emergency, and you've made plans and you're implementing your plans, but it's not, and when you're dealing with us, if it hasn't come through here, it's not a rule. It may be useful, good, worthwhile, and well-intentioned, but it's not a rule. So,
Senator, I may disagree with you on that
The
point.
next witness on telling
Well,
about.
Senator, if I may, I disagree with that interpretation. You gave us the authority to modify and vary rules, and we acted on that. While it didn't go through your committee through the normal rulemaking, we believe we used the legal authority provided by the legislature to act, and Dee can walk us through the process and how we did that.
I think,
The intent.
So,
thank you. I'm Deanna Jones. I'm policy advisor for the Commissioner's Office at Department for Children and Family. And I can point out our authority for the rules that we've posted. And it begins back with Act 91, which was originally passed in the beginning of the pandemic. There's been Act 91, Act 140, Act 6, and then finally Act 74. In Act 91, there seems to be a lot of focus on Section 1, but the specific section that dealt with benefit programs through the Human Services, Agency of Human Services, was Section 4. And Section 4 is the authority to waive and vary the rules. And it says it right in there. And if you follow Section 4 of Act 91 through the various extensions, you know, Act 140 and then Act 160, in Section 4 of Act 91 that continued to be carried through, the only thing that changed was the date that that should run through. The authority to waive and vary the rules continued. The legislature continued to grant that authority. And it was necessary to continue to respond to the developing situation on the ground. And as Commissioner Brown described, there was a lot of things going on and a lot of people were involved in constructing and waiving and varying these rules. So while the rules changed and continued to be varied and waived, there was lots of people participating, and we believe we were operating under the authority granted by the acts.
Can I say something, or do you want to add me? Are you going to say
Senator
something?
Lyons. Senator Lyons.
I want to encourage the Lcar to read all of Section 4. The intent was to support children and families receiving benefits, to allow for the continuation of operations, even with a reduced workforce, and with flexible staffing arrangements that are responsive to evolving needs, to the extent that such waivers or variances are permitted under federal law. So the intent was to ensure that people were provided the health and human services that they need going forward. That was the intent.
And that is.
Oh. Yeah.
We were operating with that intent, and Commissioner Brown was responding to the various situations on the ground with a lot of other people. And as I recall, spent a lot of time in the legislature talking to people, making sure everybody was on board with what was going on.
Jen Carvey. Or Katie.
Something to add, if that would be helpful. I think we both have something to add if you want to hear from your counsel, additional counsel. Is that?
I'm sorry, I can't hear you, Jen.
Sorry. I think Katie and I both have something to add if you're interested in hearing from other counsel.
We have two witnesses that work for the Joint Fiscal Office and Legislative Council who are our guides in what we do. And Jen Carvey wants to make a comment at this time.
Sure, Jennifer Kirby, Legislative Counsel. So the piece that I.
Chair, if I could just interrupt, you folks are going to have to come up and sit at the table because otherwise you're off camera. Nobody can see you.
Thank you, Senator Bennett.
So Jennifer Kirby, Office of Legislative Counsel. The piece I wanted, having drafted this language with the committees in Act 91 and the further acts, the piece that I wanted to flag in that Section 4 is that it allows the Secretary of Human Services to waive or permit variances from the following state rules and standards. And then it says governing providers of healthcare services and human services as necessary to prioritize and maximize direct patient care, support children and families receiving benefits from DCF, and allow for the continuation of operations. My understanding at the time was that the focus really was on making sure that the providers of services were able to continue providing those services despite what other requirements like on staffing ratios might otherwise be required. This was originally tied to the duration of the state of emergency, but then was, as was noted, extended beyond as circumstances continue to warrant. So I just wanted to provide that context in addition to what Senator Lyons said, that the focus really had been on providers of these services.
And if I may add, Katie McGlynn, Office of Legislative Counsel, the language that was highlighted in Section 6, Act 6, Section 4, does refer to the Secretary of Human Services may waive or permit variances. But there's language under the APA section, 3 VSA section 845B that says that no agency shall grant routine waivers or variances from any provisions of its rules without either amending the rules or providing by rule of process. So this indicates that there would need to be a rulemaking process to do a waiver or a variance.
Were the rules to be waived or amended as set forth in what you just read, would they come to this committee sooner or later?
Yes, they go through the typical process.
Have they come through?
They have not.
And I
So-
just want
so-
to add though, that the Department for Children and Family and the Agency of Human Services viewed the authority as the section for waiver and permitted variances as being the statutory authority to do that with the rules. And I think it's number 11 at the bottom specifically addresses the benefit programs, that's what that authority is for.
And we interpreted it as well as to supersede the APA Act requirements. Otherwise, the authority you granted us wouldn't be the authority that we needed to waive and vary rules. We would have been required to go through the same historical process, which wouldn't have given us the flexibility during the state of emergency. So for us, we interpreted that language as superseding that. And now others may disagree, but we felt like we were operating within the intent of the legislature.
Where there seems to be a recognition that there is a variance on, there's a difference of opinion on the underlying intent. We're here to listen, and we've learned that your work that you're doing, believed to be doing, and all the good reasons that you're doing it, and our legal staff says that yes, you were expected to follow and go in those directions, but you were to go through eventually this committee. And we're here to learn about what you plan to do next week, next month, and the next several months. But when we listen to what is expected to be coming forth, it's obviously coming forth with a difference of opinion on its legal authority. And we're looking at the future.
I have
this-
one point about that, which is when Act 91 was passed and then the subsequent acts, 140 and Act 6, we started posting rules in August of 2020 and posted, things changed as we went, as those acts were passed. Nobody changed that language. Nobody came, no person in the legislature, any of the committees came to AHS or the Department of Children and Families to say, and now we're going to clarify the language. We expect you to go through emergency rulemaking. Nobody ever changed the language. It just continued as it was. So our understanding was we were operating in the way that the legislature, consistent with the statutory authority that they continued to pass.
Thank you for telling us what your understanding was. So Representative,
Well, it's very interesting because now that you know now that it's been brought to our attention that this was happening and you understand that that was not the intention, but you have wanted to follow our intention, then it seems to me that now's the time to follow the intention, now that you know what it is.
With all due
Could you hear
respect, I mean, I'm
we need
not
to hear it.
still clear that that was the legislative intent or not. I mean, this committee is questioning it with all due respect, but
Say something. Yes.
Senator Lyons.
So I just want to say that there's nothing that I've seen here that notwithstands the APA language. So that would suggest that would continue to go through a rulemaking procedure. And then as to whether or not legislators read all of the rules that were posted, that is sort of a non-starter for us as legislators. But there were no issues associated with those rules, and those rules probably should be going through some APA Lcar process. So I completely understand the work that DCF and AHS has done. It's been outstanding during the emergency. There's no question about it. And most of the changes that have been made obviously have not been questioned by folks in our state, in our community. Well, here we are confronted today with questions about one of the rules that's having potentially a significant effect on some people. So that's why we're here. We're not trying to suggest that the work that you've done with your group in theoretically promulgating a rule that we may see, would be great to see it. We're not suggesting that work was unuseful, but we do need to understand what's happening to the people in the state and their concerns. So thank you. Thank you both for your comments. And thank you both for your comments.
Thank you. I think Senator Lyons spoke to the whole committee on the hard work and the efforts that have been made to get us to today. And we're meeting today to discuss or to learn what you are planning to do tomorrow and the next day and the next couple of months. But we do have a fundamental concern that the legislators and committees of jurisdiction who are not in session now, and this committee that traditionally reviews rules, modifications, waivers, don't know what you plan to do next. So do we have any other questions for these witnesses? For Mr. Brown and Ms. Jones? Will you stick with us here, please, as we continue?
yes, yep.
Good, thank you. So if these.
She's from legal aid
Yep.
and she's on the screen. And Tina has also been.
Okay, so
Chair McDonald,
yes,
I do have a question. I don't know if now is the appropriate time or not. But I guess I can ask it and see if it is. I guess I'm interested in your policy, Commissioner Brown, in regards to going forward for any new folks out there. I know you had mentioned that you're basically looking at current people that are qualified or involved in the motel voucher program or whatever it is. But what about new folks that are coming into the state? Is there qualifications around how long they have to be here, and what's happening to individuals that are new that are signing up?
So there is no residency requirement for the emergency housing program. If someone arrives in Vermont with the intent to stay, that they're relocating here, they are eligible for our programs and services in the emergency housing program. If someone is eligible, we have new people applying and being found eligible and participating in the program every day. So the program is open and serving newly eligible households every day. And they are eligible under the existing statutory framework that was in the budget bill in terms of who's eligible and for how long, and then also for the other provisions as well. And they would also then, if reaching their 84 days, would be eligible for the new program that we're standing up as well, moving forward to make sure people have a safe place with stability moving forward for a longer term.
Okay, thank you.
Jessica Radford?
Hi, can you hear me?
Yes. Did we
Okay,
get
great.
the name correct there?
Correct. For the record, my name is Jessica Radford, and I'm an attorney at Vermont Legal Aid. Thank you so much for reviewing the emergency housing waiver and variance of rules and the opportunity to submit testimony. I appreciate the engaging discussion so far. I turned in some written testimony that reviewed the status of the public health emergency and the crisis in the rental housing market that we felt pursuant to Act 74 should prompt reconsideration of the, I'll just call them rules. I know there's been some debate about that today. I'm not going to repeat my written testimony here unless you ask me to do that. So what I'm actually planning to cover is going to be why we're seeking something more than a pause in terminations of the program, the problems with the rules as they are, and what we're asking your committee to do. And I'm hoping that I'm going to give us a path forward today that will work for everyone. I'm also going to respond to a couple of the commissioners' statements. So just looking to the commissioner's statements first, just wanted to clarify that in the lawsuit that Vermont Legal Aid filed earlier this year, the substance of the lawsuit was we're challenging the disability definition in the rules, but the hook was that the rules weren't promulgated in accordance with the APA. And while we did settle the case on the substance of what that disability definition was, we never actually got to any sort of agreement on whether or not rules needed to be promulgated. And we did only settle the case on behalf of the individual clients that filed it, the named plaintiffs, as opposed to for the class as a whole. But moving on, again, I'm very hopeful that we can set a path forward that might work for everyone. Okay, so just because I'm not in the room and I can't see people's facial expressions, if there's something that's confusing that I'm saying, please do feel free to interrupt me and I'll try to break it down a little bit more. So first, why do we want something more than the pause in terminations from the program? On behalf of our clients who are in the General Assistance Emergency Housing Program, I do want to acknowledge we definitely appreciate the pause in terminations from the General Assistance Emergency Housing Program that was announced by Governor Scott. Without that pause, we would have seen around 543 of the 950 households in the program. And that's seniors, people with disabilities, pregnant women, domestic violence survivors, getting put out onto the streets on October 21st. And I also very much appreciate that the Department for Children and Families has been meeting with some stakeholders, including Vermont Legal Aid, me, to get input on how to better meet the needs of Vermonters who are experiencing homelessness. And in addition to the pause, Governor Scott announced earlier that the Department for Children and Families hopes to get General Assistance Emergency Housing Program participants leased up as tenants in motels, has put forward a number of other ideas, including historic investments in affordable housing to help people experiencing homelessness achieve greater housing stability. And we definitely look forward to working with the department to explore those proposals further. But I think relying exclusively on that pause is problematic for a number of reasons. So first, when it comes to enforceable rights for the program participants, we're really left guessing what the legal meaning of the pause is. Rules are enforceable if we go to the Human Services Board, if someone is wrongfully denied program benefits. Rules are enforceable in court. I honestly don't know what the legal meaning of a pause is. What if a person who's eligible is terminated? I don't know how the HSB or a court would address that kind of case, given that we're in a bit of a limbo here. Second, because the pause is a practice that is contrary to what's in the rules that we have, program participants are left to guess what their rights are and are experiencing a lot of confusion and anxiety. And I know Tina Gray-Rand will be describing some of this confusion in her testimony. I think it would be appropriate for the committee to request initiation of rulemaking pursuant to 3 VSA 831C to put the practice of the pause into rules. If you take a look at 831C, 25 people can get together and put in a request to see a practice put into rules, or Lcar can do that very same thing. In addition, the pause and the rules haven't been subject to appropriate review, in our opinion. The open meeting law, the Administrative Procedure Act, this committee, you play really important roles. And we have better decision-making in government when meetings are open and all the stakeholders have the opportunity to be heard. I really appreciate the opportunity to be here today. And when Lcar reviews the rules to ensure that they're rational and advancing the legislature's intent. The department did engage with some stakeholders prior to announcement of the pause. I really appreciated being part of that. But because those meetings weren't open to the public, we don't know who else provided feedback and what was the content of that feedback. For instance, I don't know what sort of guidance public health experts provided about the emergency situation that we're in right now. And I'm glad to know that you're hearing from a public health expert today. We don't know if the interests of motel owners have been taken into account, or what about the people experiencing homelessness who are living this right now? Have the interests of municipalities who are engaging with the unsheltered Vermonters who aren't eligible for the program been considered? I think there's time during the pause to have open meetings about the program rules, to get public comment, to have that all be happening in, out in the open for us to discuss. Have the department put together a coherent set of rules that address non-congregate shelter needs of Vermonters experiencing homelessness, while we still do have this ongoing public health crisis and pretty unprecedented crisis in the rental housing market. So second, looking to the rules themselves, you're not a policy committee. I just wanted to flag some problems in there. Act 74, as I described in my written testimony, it always anticipated that the program rules would be modified if there is a need to expand eligibility in response to a public health emergency or other emergency. And I think there's been acknowledgement that those emergencies do exist from the administration. We've seen that they have put the pause on terminations, but a rule change is really what's called for under the circumstance. And I'd just like to, flag your attention, if you haven't had a chance to look at it yet, the document that Vermont Emergency Management sent to FEMA, acknowledging that there is a public health emergency that warrants providing non-congregate shelter. Okay, so a few examples of the rules that we think warrant review right now. So that would be EH 700. That's the 84-day time limit on benefits other than for families with kids and people with disabilities that significantly impair activities of daily living. With the ongoing public health crisis, it doesn't make sense to have that 84-day limit anymore. With the fact that there's no rental housing for these folks to go to, in spite of the, emergency rental assistance availability, that's great, but there's nowhere for them to go. And the pause isn't actually reflected in the rule, right? The rule still says there's an 84-day limit. The pause says something different, but again, what is the pause? The rules and practices should actually match with each other. So that's what we want to see happen. EH 730, that's another one. Even if a household satisfies all the other eligibility criteria under EH 730, family is ineligible for emergency housing for 90 days if they cause their own loss of housing. And that includes families with kids. Right now, kids are still unvaccinated. Our schools are seeing significant outbreaks of COVID-19. I don't think it makes sense to bar homeless children from emergency housing based on the mistakes that their parents might have made that got them evicted. It's bad for public health. It's bad for the well-being of those kids. EH 755, that's households including a person with a disability that significantly impairs activities of daily living, can request 30-day extensions beyond the 84-day time limit. That definition has proven to be very difficult for program participants and service providers to understand. It's a little unclear what that means. Right now that's on hold, right? But again, that's not reflected in the rules. So some folks had put in a request for an extension and don't really understand what's happening with it now. Another thing, which isn't actually in the rules at all, is there's an essential payment program. I provided the committee with a notice of change that went out, I believe on October 18th or 19th. And if you look at that, you'll see a discussion of the essential payment program where people, depending upon household size, can get $2,500 to $4,000 if they're exiting the program. But there's nothing in the program rules that says that if someone takes that money, they're not eligible to come back in. There's no basis to deny benefits in the future in the rules. So those are just a few of the mismatches and problems that we're seeing now between the emergency housing waiver and variance of rules and what's in the pause. And some of the things that we think also just don't make sense in light of the ongoing public health crisis and the lack of affordable housing for people to move into. So what can Lcar actually do about this? I think today's hearing was a great first step, but I think it's a first step. It's a launching point. So my hope is that it's a little different from what I had put into my written testimony. I think what probably makes the most sense is pursuant to 3 VSA 831C, Lcar can ask the department to develop a set of rules that isn't inconsistent with the practice and procedures. And then under 3 VSA 844F, Lcar can also just express some concerns if you want to now, that the current rules don't make sense in light of the ongoing public health emergency and the crisis that we're seeing in the rental housing market. And then next, and this is a little bit later, once the department has put together that set of rules that reflects everything that's happening now, and they've gotten that important public input, Lcar can review those rules, hear testimony on what the department is doing and why, review the public comments that get received, maybe at the November 4th or even the November 18th meeting. The pause does give us a little bit of time to really dig in here and figure that out. And I know that's something the department has started doing. And again, I really appreciated the opportunity to participate in those discussions, but I think taking some time, having open meetings, public comment, getting input from a variety of different stakeholders is going to be really important. And then coming back to this committee once that's been put together into a set of rules. So thank you for the opportunity to testify today and your willingness to review the waiver and variance of rules and the pause. And I welcome any questions from you.
Any questions from members of the committee? Representative Odie.
Thank you very much, Attorney Radbourd. Lcar, you said Lcar could under 831F do what? I just missed the words that you said.
7:30.
Oh, sorry, was that for me?
Yes.
Okay, great. Under 831F, pulling out my statute book, Lcar, sorry, if I said 831F, that was an error. It's 831C. An agency shall initiate rulemaking to adopt as a rule an existing practice or procedure. So even if we're deciding the emergency housing waiver and variance of rules aren't rules because they weren't appropriately promulgated in accordance with the APA, it is definitely, we've got practices and procedures, both in the waiver and variance of rules and what's happening during the pause, which is really different from what's in the rules, right? So an agency shall initiate rulemaking to adopt as a rule an existing practice or procedure when so requested by 25 or more persons or by the Legislative Committee on Administrative Rules. An agency shall not be required to initiate rulemaking with respect to any practice or procedure except as provided by this subsection. So I am asking you to assert your authority to say, hey, let's get some rules going here.
Thank you.
Our counsel,
I would just draw your attention in that language. It says initiate rulemaking. You cannot require the adoption of the rules. So initiate rulemaking is not the same as requiring the adoption of rules, which you do frequently see in statute. You say you shall adopt by a certain point. Also, the rulemaking process is, as you know, long. So it is not like it was necessarily, even if you did and ask them to initiate rulemaking under 831C, it's not like it would happen tomorrow.
Although
It could,
actually,
maybe
I
not.
would like to add, under Act 6, it would be my interpretation that Act 6, Section 1 did say that this is an appropriate time to engage in emergency rulemaking. So for emergency rulemaking under 3 VSA 844, it's the agency should get as much, provide as much notice and opportunity for public comment as is practicable under the circumstances, and then doesn't need to go through the normal rulemaking process, can just file with this committee and with the Secretary of State. So a much more abbreviated process.
It is totally accurate. If they were so inclined, they could, just take this document, change it in a way to put the pause in it and adopt it as an emergency rule, as soon as they could get their filing together. That could be a quick process, but I don't see language that puts Lcar in a position where it could require that. That would be something that the agency would be choosing to do. Maybe in response to Lcar requesting that it do that.
Senator Bray.
Question for our council. In terms of our ability to hire the initiation of rulemaking, does that cover both regular rulemaking and emergency rules?
This language in 831C says an agency shall initiate rulemaking to adopt as a rule an existing practice, et cetera, et cetera. It does not specify under 842, which is the path for, or there's more language. It doesn't say it's limited or it excludes 844, which is the emergency rule making process. So I would say it is not clear as to which it is, but adopting a rule covers both emergency rules, which is 180 days in length, and permanent rules. So I think it is open to interpretation. It does not preclude or require it to be one path or the other.
And so if I could, well, I'm sorry, if I could just jump in for a clarifying point. One of the concerns of the administration and the department regarding emergency rulemaking or formal rulemaking is we are still in a dynamic situation where we do continue to make modify and variances and waivers to our rules. And we have that authority based on what we've discussed. And so if we start a formal rulemaking process, we may be we could issue 2 variances to that before it's even formally promulgated because of that. And I think it goes to the intent of what the authority the legislature gave us that D reviewed, which is what we're acting under, which gives us the flexibility to respond versus going through these very rigid formal processes that do take time. And what, I think we're concerned about starting a process that we might vary or waive 2 weeks later, depending on if we're responding to something. And so, and I think the other point I would make is no one is substantively challenged here today, whether the rule that we posted, that we modified and varied to comply with the session law in the budget bill is contrary to the intent of what's in the budget bill. I don't think we've heard anyone share that concern today.
Thank you. This committee or the legislature may in the near future modify the process for emergency rules as we often do after emergencies. And thank you. That's the legislature, not us. would do that. Yeah. Any other questions for the witness? Senator Bray?
It could be for the witness or our witnesses plural or our counsel as well. So at different points, people have used the term state of emergency or crisis. I guess state of emergency might be a legal status, and I'm unclear as to whether or not or the other phrase I heard was public health emergency. So I'm just wondering if we get some clarity about what our legal status is around those terms and what the implications of either being in a public health emergency declared, being in a state of emergency declared is or is not. I just don't know how that affects our decision making.
On behalf of Ledge Council, I don't think I'm necessarily the best person to answer that question. I don't know if Jen or Katie or administration.
Yeah.
So we have 20 minutes left. We have 2 witnesses to hear from. We're not going to get into modifying rules. We're trying to follow what's going to happen tomorrow and the next day, and on the issue that this hearing is dealing with emergency housing. And so
Sure, I'm trying to recollect now off the top of my memory, but we did.
For the record.
For the record, Kate McGlynn, Office of Legislative Counsel, that the term of public health emergency isn't a term in statute. The phrase in statute is the state of emergency. So in terms of there being kind of a legal public health emergency, that's it's not a term used or a status. Well, within the state of Vermont, it's not a status. Whereas the state of emergency is the phrase that's used in the Vermont statutes annotated.
And I'll add Jennifer Carvey, Legislative Counsel. So the state, as Katie said, the state of emergency is the term that's used in our statutes. It triggers declaration of a state of emergency, gives the governor additional powers that the governor doesn't otherwise have outside a state of emergency. Public health emergency is a term that the federal government uses, and I believe we are still in the federal public health emergency, and that triggers certain changes or additional authority because of the federal public health emergency. So there may be that terminology may have been what was used between Vermont Emergency Management and FEMA, for example. I'm not sure if that was the context that term came up in, but because it may have some implications for the state as long as the feds are continuing that public health emergency. So I think that the terms get used to sort of loosely to describe the unprecedented circumstances under which we are all now living. But their actual application in this particular circumstance, I don't think is necessarily affects what Lcar does or doesn't do.
Okay. And one quick question.
could we've got 2 witnesses that are here that are not at our beck and call on the issue of the housing.
Sure. I just wondered, are we in a state of emergency now? Has that terminated by the governor?
If the governor has terminated the state of emergency.
July.
But there are several different federal states of emergency that continue to apply.
Thank you.
Thank you, Senator. Good question. Ann Sosin? From a policy fellow at Dartmouth College dealing with housing issues. The floor is yours.
Good morning, Chair McDonald and members of the committee. Thank you for reviewing the emergency housing waiver and variance of rules, for giving me the opportunity to speak with your committee this morning. In my testimony, I would like to first review why the current evidence and public health data continue to warrant protective non-congregate shelter in Vermont beyond December. 2, why the program represents an important tool for responding to the pandemic. And 3, why we need more than a pause on the current program. I've already submitted written testimony to the committee, and so I'll briefly summarize some of the evidence that I reviewed in this during my comments. First, I'd like to describe why the current evidence and public health data continue to warrant protective non-congregate shelter. Vermont has ended its state of emergency already. However, the public health emergency in the state has not ended. Since the start of September, Vermont has registered its highest single-day case count, highest 7-day rolling average, highest number of cases in schools, and second highest monthly death count since October. September was the second most deadly month of the pandemic, and more Vermonters have died since September 1st than during the first 8 months of the pandemic. Available data shows that 1 in 3 COVID-19 deaths between September 15th and October 15th have occurred in our nearly universally vaccinated long-term care facility residents. Hospitalizations in Vermont are approaching our pandemic high. This current surge is impacting the state's health system, schools, and citizens. Many factors suggest that Vermont will experience a prolonged surge similar to the United Kingdom that will continue into fall and winter. Ending housing protections, including non-congregate shelter through the General Assistance Emergency Housing Program, is likely to accelerate increases in COVID-19 infection rates and secondary impacts on our health system, schools, and community services. I'd like to continue by describing why this program represents an important tool for controlling the pandemic right now. Growing research shows that the GA Emergency Housing Program has played an important role in protecting Vermonters experiencing homelessness.
Can the folks on the screen hear the witness?
Shout.
Speak up, please. It's
Okay.
loud.
We have growing evidence that showing that the GA Emergency Housing Program has played an important role in protecting Vermonters experiencing homelessness and in controlling the pandemic in the state. As I highlighted in my written submission, we have evidence that the housing protections prevented the high rates of COVID-19 in our congregate shelters, as well as the elevated mortality in unhoused populations that we've seen in other states. In addition, we have growing evidence that housing policy represents an important tool for controlling COVID-19, not only in unhoused populations, but also in our broader communities. States across the US that lifted their eviction moratoriums saw greater rates of transmission than those that maintained their policies, including the state of Vermont. For this reason, the public health community increasingly recognizes that the housing policies that Vermont employed as a primary tool of pandemic control that will continue to be important in managing the pandemic and future public health emergencies. I'd like to conclude by just discussing why we need more than a pause on our GA emergency housing. The pandemic has helped Vermonters to understand the importance of housing and health, but we have strong and consistent evidence on the importance of safe, stable housing for health. Extensive research over many years has demonstrated links between a range of housing and health conditions, and several studies show that unhoused, unsheltered people are at significantly increased risk for death compared to the general population and the sheltered unhoused population. The evidence is clear. The impacts of homelessness on health are not time-bound or limited to COVID-19. And the rules governing housing protections should not be either. The current GA emergency housing rule limits our ability as a state to respond to the current public health crisis and does not equip us to utilize housing as a policy to address future challenges. For these reasons, I joined Vermont Legal Aid in urging you to review the GA emergency housing rules. Thank you.
Any questions? Witness?
I say thank you, and thank you for including your references in your testimony.
Thank you.
Tina Gray Rand from Berlin. Tina Ray Grand on the screen.
Yes.
The floor is yours. Are you muted? Oh,
Tina, you should be able to talk. Been on through the whole meeting. She's not muted. So, Tina, are you able to speak?
maybe if she turns her video off, her audio will come through. We're not hearing you.
Your hand up if you hear us.
I'm chatting with her in Zoom. So,
Action.
still there. Oh, now she's on mute. Tina, go ahead and try. Video's on. She's unmuted, but we're unable to hear her.
Well,
Chair, can I ask council a question while we're trying to iron out the technical difficulties?
certainly.
If we are of a mind to ask the agency to initiate rulemaking and they do not, what happens then?
I would need to look into that. I'm sorry. Reach out to some of my government operations colleagues and
I mean, if we end it,
I can tell you that it is not something in the statute. It says, as the language that Jessica Radford read, an agency shall initiate rulemaking to adopt a rule. And it says that they shall not be required to initiate rulemaking with respect to any practice or procedure except as provided by this subsection. But it doesn't say what the consequence is if that is not done.
Thank you.
show up, so we just have-
Oh,
Okay.
but one thing you could do is, kind of circumvent come January and actually enact laws. You always have the power to do that. So I know that is not an immediate course of action, but as the General Assembly, you do have the ability to respond in that way in the future. I know that is not the immediacy for this panel.
Thank you.
I think the witness is here.
Chatting with her about how to call in, so hopefully she's able to see that. Tina, if you can hear us, please check your Zoom chat for caller information.
I think you are finding through practice and interpreting the APA that the APA does not address some of the
It's a real issue.
in dealing with the state of emergency. One thing I will say, I didn't respond to it earlier because I thought it was a case response to a question.
We analyze it. Are we on live now?
Yeah,
We're still live.
yes,
So,
we are. Anthea.
Oh, I could talk louder. I was merely commenting on Senator Bray's earlier question about who would make a determination as to whether or not it was a policy or a procedure or a guidance document. And as Jessica Radford has mentioned, part of the litigation that they brought did address whether or not this had been adopted as a rule. And it sounds like there was no resolution reached on that portion of the litigation. That is, and Senator Bray remarked that maybe this experience is pointing to some areas where the Administrative Procedure Act could be amended to better address these possible situations. It does say, and I believe without having read the litigation that was filed by Vermont Legal Aid addressing the failures and deficiencies in adopting this as a rule, section 846 does say the following shall prevent a rule from taking effect. And some of those are things like failing to file with Lcar, failing to file with Icar, failing to file with the Secretary of State's office. So that is not something that statute contemplates Lcar determining, but it is something that the statute does contemplate, the scenario where maybe a rule was attempted to be adopted in a way that is inconsistent with the procedural requirements of the Administrative Procedure Act. But
Sorry, go ahead.
I was just going to say, you know, as with so much of laws, the APA was not necessarily written in a time that contemplated that it would need to be as fluid as maybe the commissioner is indicating it needs to be now. And I think this has been a solid learning experience to maybe find ways to make the Administrative Procedure Act function a little bit better in the unique situation you're now in.
But it does raise two issues. One of those issues is something that we have discussed in our Health and Welfare Committee, which is a need for language related to prevent future such emergencies, regardless of their type or source. But then the other is the rulemaking process, which we hadn't yet, and I don't think we had it yet, included that in our discussion on the bill that we were looking at in committee. That may be a whole separate analysis. I think every committee in the House and Senate will have to evaluate process policy-wise for a state of emergency and work with emergency management and others on it. I mean, so this does for me raise that bigger, larger issue. Again,
We, as usual, we've learned that our powers on this committee are limited. We cannot change rules. We cannot establish policy. We can only recommend to committees of jurisdiction. We have watched the administration in many cases work quickly and speedily to deal with the emergency. And I think most of us are impressed with the work and the diligence. This particular issue on housing with suggestions that people, rather than being prioritized for housing or maximizing the benefits, there's now thought of withdrawing and ending benefits is a policy change. And the administration would do well to involve as many people as possible and try and resolve this in a way that has been consistent with their efforts to extend benefits and keep people safe. Does anybody have any other comments as this hearing wraps up for today? Senator Benny.
Mr. Chair, when we began the conversation, it was a promise to open up the discussion for people to present the issues and for us to learn what's going on. It's become apparent to me two things. One is this entire system of operation, this emergency, declare it an emergency or not, is in need of some legislative intentions. We have to have the legislature revising the ADA or accommodating. I am also impressed that the administration is trying to do its best under the circumstances to adjust and meet the expectations of people. Having said that, I'm also concerned that there appears to be no specific guidance. So when Representative Higley, for instance, asked the question, residence requirement where you're making decisions on who gets allocated a finite pot of money, a finite set of housing, they don't exist. And I'm concerned that if I was in their position, I would want to have some rulemaking initiated, but I don't think I'm comfortable in asking Lcar to make that claim to them now. So with respect, I think we have dealt as much as we can within the time allotted, and would hope that people continue to operate in the best of intentions until the legislature gets back into session and the legislature can deal with the issues. But for now, I think we have exhausted our possibilities here this morning, therefore move to adjourn.
Can I add to that? I think what I'm hearing you say is that we have heard from the public. This is a public hearing. So we have heard from the public on this issue. We've heard some very compelling testimony. We understand the rock and the hard place that the administration is under, but we also understand our role in approving this type of rule. And so I guess my recommendation would be that we, I'm not going to make the motion, but I'll suggest to the chair that we could have a motion to close the public hearing. We haven't heard that there are others who wish to testify at this point. And then, you know, as with any other public hearing, the information that we heard suggests possible legislative action, as well as possible action on the part of this committee, sending letters or whatever other authority we have going forward. So that's my suggestion, and that's open for further discussion.
Technically, I made a motion to adjourn.
The public hearing.
Move we adjourn the public hearing.
Senator Benning, thank you for your comments today. And I thought perhaps you were going to bring up our issue with judiciary and the closing of the courts, which has been done as an emergency without a formal, and when does it end? And I don't know what our role is in that, but it's something that needs to be addressed sooner rather than later. As
just for the chair's edification and for the committee's edification, that conversation is now taking place amongst members of the Joint Committee on Judicial Rules.
Where it should.
And if it doesn't go anywhere, perhaps I'll come back to Lcar.
Are we going to try and hear from Tina Gray?
So I've been in contact with Tina as well as Jessica Redboard. She's having technical difficulties with her computer and her phone she's unable to call into the meeting. So she's going to we're going to try to get her to send written testimony, either snail mail or through email here. When it comes to me, I will distribute it to the committee members and post it to the committee's website.
Thank you. Thank you. So the motion has been, Senator Benning, did you move to adjourn?
I did.
Okay. Is there any further discussion? If not, all those in favor say aye.
Senator McDonald,
Oh, forgive me.
sorry.
Right.
Before we're all done, I know that I appreciate Senator McDonald's, Benning's comment that, you know, that legislative action that may be when the session recommences might be the best place to work on the issue. The challenge I see is that the extension is through the end of December. So we end up with the benefits cliff. And even if the legislature acted remarkably quickly, we might end up with a gap that would be very problematic for a lot of people. So I'm just sharing that for the record before we.
So if I could just jump in here to correct the record, I think there's a misunderstanding. There is not going to be a benefits cliff at the end of December. Folks who will no longer be eligible to stay in this program will be able to participate in this new program, rental assistance, that will be able to access motel rooms the same and stay where they are through this other program outside of the emergency housing program. There will not be a benefits cliff. I think that's what I've been trying to stress.
Thank you for that correction.
So our witnesses are pleased to have heard that clarification and emphasis. Motion has been made to adjourn.
End the public hearing.
End the public hearing. All those in favor of ending the public hearing, say aye.
Aye.
All opposed? And the hearing is ended. Any other business?
I'd like to make a motion to adjourn.
Senator Benning is move that we adjourn our business as Lcar for the day.
Can I just ask that at some point we add on to our agenda a discussion after we've had some time to reflect on the information that involves the APA and rulemaking and everything we've heard today, that we take a little bit of time at one of our meetings where we have time to discuss it, please.
We will also ask council to list a couple of those areas and the choices that we might want to recommend to the jurisdiction.
Terrific.
No further discussion. All in favor, say aye.
Aye.
All opposed, say nay. And, thank you all.